Good morning, everybody. Our topic is issues of aging, making your own decisions. Today we're going to talk about advanced directives and final decisions on today's edition of Senior Moments. Our guests today are Curtis Woods of Eternal Valley Memorial Park and Mortuary, and Gina McDonald, estate planning and elder law attorney. Gina and Curtis are guests and co-hosts before. Gina has extensive experience in trust creation and administration, probate, conservatorships, guardianships, Medi-Cal, and elder law issues. She has over 40 years of experience in the legal field and has been a practicing attorney for over 25 years. Gina is a member of the Santa Clarita Valley Bar Association and the San Fernando Bar Association. Curtis Woods is general manager of Eternal Valley Memorial Park and Mortuary and serves on the executive committee and is a board member of the Santa Clarita Chamber of Commerce and a member of the Santa Clarita Senior Resource Alliance. Welcome, Gina and Curtis.
Thank you for having me.
Thank you. Good morning.
Good morning. And Curtis, it's nice to see you at the other end of the microphone this morning.
It's a little bit different, but I like this perspective. This is nice.
Absolutely. We switch it up once in a while.
Awesome.
Let's begin kind of with advanced directives. We talked a little about this before, Gina, and we probably should continue that discussion. For those that did not have an opportunity before, what does the term advanced directives mean?
Well, first of all, when you say an advanced directive, a lot of people look at that as the advanced healthcare directive, because when you're looking, or sometimes people call it power of attorney for healthcare. And people get confused if they see a document that says power of attorney for healthcare, and they say, well, is this an advanced directive? I want you to understand, a power of attorney for healthcare is the equivalent of an advanced healthcare directive. We have different types.
Like what?
Well, under California Probate Code Section 4701, there is a very abbreviated directive. What you're doing in a healthcare power of attorney is letting the agents, the people you're picking to talk to the doctor when you can't, letting them know how you want to be taken care of in different situations. And mostly when you're looking at the statutory healthcare power of attorney, you're going to see that you designate an agent and you're letting the agent know what type of post-death authority you want to give them, when the authority becomes effective, what type of authority they have, and in many situations you are also nominating a conservator.
Can I just do that? Can I just say to my friend Bob and my daughter and my son-in-law, I want you to do this, you to do that, and you to do that?
Well, remember the person who's looking at this healthcare power of attorney to know who the point person is when we have someone who is very sick and unable to communicate with their doctor.
But can I just do that verbally?
It's worth the paper it's written on. What you're always looking at within the legal system is it's worth the paper it's written on. Now, a lot of people ask me, well, why do I have to have a nomination of a conservator in this document if I'm nominating a person to be my agent under a healthcare power? That's because a conservatorship is a legal proceeding, and there's two types of conservatorships. First of all, a conservatorship is an adult guardianship. You know, when your kids were small, that if anything happened to you before they turned 18, they were going to have someone who was legally responsible for them.
But can I just tell somebody to do that?
In one word, no.
Okay, why?
Well, because, especially on a conservatorship or anything else, like I said, I'm a doctor. How many people could come up to the doctor and say, this person told me that they want me to do this? The doctor's not going to accept that type of liability,
right.
And the doctor is not going to follow through with what somebody is saying. And my axiom, it's worth the paper it's written on.
Right.
Now, I was talking about conservatorships. A conservatorship is an adult guardianship. A power of attorney for healthcare deals with many issues in healthcare, but it does not deal with your mental status. We have a different court when it comes to mental statuses, and it's called the Mental Health Court, and it's in Los Angeles, and it's a separate little court that deals with issues of mental health. One of the things of mental health is when you have dementia, when you have Alzheimer's, and you are maybe making decisions that aren't in your best interest, although you believe they are. Well, there is a conservatorship for mental health that takes care of some of those issues, but it's a very serious conservatorship because the court is giving that person the ability to make you stay in a hospital, make you stay in a healthcare facility.
And they can do that?
Under a mental health conservatorship, not under a power of attorney for healthcare. And people get confused. They think they have total power to do everything.
So two different things.
Two different things. So that's why in these healthcare power of attorneys, there's normally a nomination for conservator of the person, meaning making decisions regarding your person, your healthcare, and conservatorship of the estate. That means taking care of your money. Mm-hmm. Now, under a statutory power of attorney or advanced healthcare directive, you'll see that you can let people know about end-of-life decisions.
Can I just tell them? Do I have to write all this down again?
Well, like I said, the doctor is the person that you're waiving this healthcare power at when all of this is happening. We've had a lot of people who don't want to be kept on machines to keep them alive. And so under a healthcare power, a statutory one, you can make a choice not to prolong your life or to prolong your life. You can let people know, keep me on machines. I want to be on machines for a certain period of time. You can also deal with donations of organs at death. For the statutory power of attorney, anybody can go on the internet and they can look up California Advanced Healthcare Directive or put in California Probate Code Section 4701. They can print out a blank form and they can fill it out. But another good source is a lot of times your healthcare provider. I know that FACey gives their individuals the opportunity to receive a blank form. I know that Kaiser has not only put together a healthcare power of attorney for individuals, but then gives them extra sheets to be able to fill in choices and things like that. So I want people to know that they don't have to go see an attorney to do a healthcare power of attorney. They have choices. Now, the one that you are filling out is the statutory probate code one. That doesn't always give you all the options that an attorney preparing a healthcare power of attorney has.
Like what?
Well, let's see. I'm looking at one of the advanced healthcare directives that we do in our office. And it talks about who successor agents are going to be. It talks about a general statement of authority of the agent. It also talks about something called HIPAA authorizations. And you know what? That's become a big deal. It's become a big deal because we have issues of privacy. And I want people to understand that just because they gave somebody a healthcare power of attorney does not mean that they gave that person the right to get their medical records. We have privacy issues. So if they have not completed a HIPAA authorization in addition to an advanced healthcare directive or power of attorney for healthcare, they've only handled medical wishes. They haven't handled the ability to get medical records.
Well, so this is getting really complicated now.
Oh, yeah.
So far, I have 2, possibly 3 documents that I need to have.
I know.
So I'm done now, right?
It depends on what you're trying to accomplish. If you're telling me that what you're trying to accomplish is making sure that you can have someone appointed as your agent and to get your medical records, Curtis, you're right. Now, at what level you're doing it is up to you. You're using either the statutory power of attorney and a HIPAA authorization, or you're using one that talks a lot more about powers of the agent, making decisions as to personal care, authorizing medical treatment.
And just very quickly.
Go ahead.
And I can take these documents, I can put them in an envelope and take that envelope and slap it on my refrigerator and I'm done.
Well, as my mother used to say, in your dreams. Once you have completed these type of documents, if you don't let somebody know you've done it, it means nothing. And I think it's wonderful that you want to put this on your refrigerator. However, we let our clients know when it comes to the original, we want it in a safe place, and we want it with your estate planning documents. Here's the reason. A power of attorney, if they're asking for the original and you can't produce it, under the law, it's presumed revoked. You can have all the copies in the world. So you need a safe place for that original. And yeah, I want you to make a lot of copies of this healthcare power. I suggest you put one in your suitcase because when people travel, they have boo-boos. I want you to put one in the glove compartment of your car because if you are in a car accident, at least we know that emergency personnel may be looking in spots to know. I want you to put a little card in your wallet that says you have a healthcare directive. I want you to let the people that you have nominated know that you have nominated them because guess what? This is a volunteer position. They don't have to do this. Right. So a lot of times what I'm asking, because we send out questionnaires to our clients to fill in before they ever see us, and what I'm asking them to do is speak to the people you're nominating.
Right.
Because unfortunately, they don't have to serve. And you don't want to put them in a position where you've done this and they had no idea. It's the same thing when you nominate people in a will. It's the same thing when you nominate people in a trust. All of that stuff.
Same thing for you, Curtis.
It's the same thing, and it's like sitting here listening to what she's saying is like, it's like music to my ears because everything she's saying is so accurate. Healthcare decisions are so important not only in life and as you're progressing through whatever situation you're in, but it's even more important when it comes to final arrangements. Without either having all your sisters and brothers gather at the same table at the same time with my facility, that healthcare document is like gold. And having one of those in place, filed, shared, just like you said, share it with your family, share it with your friends, share your plans, speak to the person that's responsible for these decisions. All that stuff, what she's saying, is just so important. And for a person to not take the time to at least download the basic copy, make the basic statements, and keep it in a safe place, I think we're all missing out on an awesome benefit that we can all take part of.
So, do we need any more documents here? Because I'm starting to get overwhelmed with documents.
Tell me what you're trying to accomplish, and I'll let you know.
Okay, I have a house. I have a car that's paid off. I have some savings. I have some stocks. But I can just say, hey, Joanne, will you take care of this? Joanne says, yes, I'm a done deal.
No.
Right. Still
now,
no?
Well, see, what you did was, now you added, you didn't say just health care. Now you said, I have a house, I have a car, I'm telling my friend to take care of all of this if something happens to me. Now, did you notice you haven't told your friend what you want to do with it?
Right.
I want to give my house to one child, I want to give my car to another, and I want to divide the liquid assets amongst them.
Okay. If you don't have at least a will to do that.
I need a will now?
Yes, because otherwise you have state of California has said if you don't want to do anything about that, that's just fine. We have a statutory scheme to take care of these things. The only trouble is that statutory scheme doesn't say when you die you can give this to this child and you can give this to another child and these things can happen. What it's going to do is it's going to use the scheme that says if you're deceased and you have children, and you have parents who are living, they will be considered both being in the first degree, and your estate will be divided among them. So having a will, and again, just like we were talking about the advanced healthcare directive that you could get something off the internet and fill it in, anybody who's on the internet right now, you're hearing LegalZoom for a super duper price wants to give you a blank document for you to fill in. As long as you can understand the directions they're giving you and you can fill it in and you feel confident that you have filled it in correctly, then you know what? You don't have to see a lawyer. However, you're taking all of the responsibility for making sure that what you put in that document is what you want. Now, just to get back for a second, you know how Curtis was talking about on healthcare powers, burial instructions and everything? A healthcare power itself leaves it kind of innocuous. It's a very short document. When you go see an attorney who's giving you a healthcare power, you will see, like for us, Section 5.6 of this 9-page healthcare power says you're giving the agent specific taking actions after the death of the principal. And it says that agent under the healthcare power has the power to receive any and all items of personal property and effects that may be recovered from your person, to consent to the examination of your body after death to determine the cause of death, to make disposition of your body or parts of your body under the Uniform Anatomical Gift Act, and to direct the disposition of your remains under Health and Safety Code Section 7100, and to arrange for my funeral and burial and other related arrangements. This document, there'll be no fighting over who has the power to do what needs to be done.
And is that important? I mean, I already spoke to all these people that I mentioned to you, and they're all cool with the idea that when I go, they know what their responsibilities are.
And again, if you are sure that your family, you don't know how many times people say to me, well, they all get along. Under stress, it's really hard for people to agree on what is going on because they have a life experience they are bringing to the table at the time that you die. And so their decisions as to your burial, what's supposed to happen, how things are supposed to be, can be very different. And I know as a parent, the last thing that I want to do is to break up a relationship between my children after I'm gone, because that's irreparable.
Agreed. Wow. So I have to have more documents.
Yeah, you have to.
Oh,
For what
man.
you told me you wanted to do, yes, you have to have more documents.
Okay. Well, we're going to have more documents. No choice about it. When we come back, we're going to talk more about our Issues in Aging series, Making Your Own Decisions, Advanced Directives, and Final Decisions on today's edition of Senior Moments. We'll be back right after the break.